hope I don't start sweating now. I done ran, child.
Welcome to Food for Thought. This is Kevon Turman, and I have two very special guests with me today. We're very excited, but before we get started, we're going to go ahead and give you our quick intro. Yeah. Welcome to Food for Thought. This is Kevon Turman, and I had two very special guests with me. I'm very excited because this is my 15th episode, which is bananas because I feel like we just started. So this is the first season, and we're ending this season. But the irony of it all is that my very first show I started with Shari Fleming, who I have with me as my very special guest co-host. So I'm going to let her do the honors in terms of introducing this special woman that we have today that's going to give us a little insight on divorce and all the things that we may need to know. Shari?
Hi, guys. Thanks for having me back, Kev. So I want to introduce to you today my friend, Keisha A. Garner. Keisha and I went to law school together at the University of Maryland. She is a dynamo with her own practice at representing clients in both the District of Columbia and Maryland. And so I'll let Keisha tell a little bit more about herself, but I'm so excited for her to share specifically about divorce and the specifics that you need to know about estate planning as it relates to divorce.
Wait, back up. So that means Keisha can't help none of my folks in Philly?
Nope.
But y'all gonna kick that disclaimer again? Because that's all Shari said. Shari was like, yeah, I can't help you. I can only do Maryland.
Right.
Go ahead, Keisha.
I actually do have a lot of family members in Philadelphia because I grew up outside of Philadelphia. So
okay. All right, we got a connection, but you can't help us.
I can't help you.
Tell us a little bit about yourself.
So thank you all for having me this evening. My name is Keisha Garner. I'm the owner of Garner Law PLLC and a divorce and estate planning strategist. I advocate for individuals through the divorce process, and I help them to create an estate plan to preserve, protect, and pass on their legacy to create generational wealth. And so I'm excited to speak with you all this evening to give you some insight on topics involving divorce and estate planning. But as you all indicated, just a brief disclaimer that while I am an attorney, I am not anyone who is watching. I'm not your attorney. And so anything that I say should not be construed as giving legal advice. However, if you are in Maryland or the District of Columbia, which is where I'm licensed, and you would like to contact me for a consultation, I'll leave my contact information at the end of the presentation so that you will be able to reach out to me if I can assist you.
Thank you. So listen, I think we're going to switch up the format a little bit. I know you have a presentation that you'd like to go through. And if you're okay with me stopping you periodically, then I'd like for you to just kind of take it and run with it. Is that cool?
Sure.
All right.
Yep. Feel free to stop me when you want to get deeper into some of the topics that are going to be covered in the slides.
Now, I know you can add it on your end. Do you want me to add
the slideshow?
Yes.
I think I'm already sharing. Do you see it?
I see it now.
Yep. Okay, cool. All righty. So again, as we stated, we're going to talk about divorce and estate planning and some of the things that you might need to know. So the first thing that I want to talk about is a lot of people have a myth about why they don't need an estate plan. So there are a couple reasons why people say they don't need an estate plan. One of them is they say that they don't know a lot, or they don't own a lot, they're too young, or they're not wealthy. And of course, those are definitely myths of why someone does not need an estate plan. So the facts of why you do need an estate plan is that you need to plan in case of a disability, in case of death, and then we're talking about today in cases of a divorce. And so if you have any of these items that are listed on this slide deck, which is a car, a bank account, a house, insurance, jewelry, you have an actual estate that you really need to plan for what's going to happen to those things once you're not here, or if you have to go through a divorce.
Now, Keisha, and this is funny because when Shari and I first sat down and talked, we had a bit of a discussion on this, because I think a lot of people would argue, particularly just those of us, and I know that I grew up with in my community, would associate the word estate with something much larger.
Right.
Simply put, estate is just anything you
own.
Okay.
Anything you own. I mean, it can include the furniture in your house, jewelry, anything that you own that has a value to it is a part of your estate. So that's why I think it's a big myth when people say, I'm not wealthy, or I don't have, I don't own anything. You do own things. Even if you think that it doesn't have any value, furniture, you may have something that's like really sentimental to someone in your family that maybe it didn't even cost a lot of money, but the wealth, the amount of it doesn't determine its wealth to maybe your family members once you're not here anymore.
And I would even add stuff that items, particularly intellectual property that you own, that you create. I know many people who have written books, who have manuscripts, who maybe people get them trademarked or copyrighted and they haven't, but they have them. Those things you can also leave. Those are things that you own and are your creativity that you should also plan for.
Definitely. So now I'm going to explain, why you need a estate plan for all these different stages. But the first I'm going to go over is the disability. So, you may at some point become incapacitated or disabled in some way, and that would prevent you from being able to do things for yourself. So in that event, you would need a document that's called a durable financial power of attorney. And so what that document does is it appoints someone to act as an agent on your behalf. And so that enables someone to manage your financial affairs if you're unable to do so. So that person will be able to write checks, deposit checks, purchase or sell property, sign contracts, manage investments, anything that you would be able to do, they would be able to step into your shoes and do those things for you. And I know I have a lot of times people come to me and they say, I need a financial power of attorney. My grandmother's in the hospital. I need to be able to pay her bills for her or talk to the banks on her behalf. And grandma might be in the hospital and she may, be in stages of dementia or maybe, be going into a coma. And a lot of people wait until the last minute to get these documents put into place. But you cannot get these documents put into place if the person who needs to execute them is in a coma or, is going through dementia, because that person who executes it has to be competent to execute the documents. So, I mean, for this document, I really want to stress the importance of getting these documents in place early on, because a lot of people don't think about it. And by the time they think about it and actually need it, it's too late. You can't get the document.
All right. So, Keisha, just really quickly, I hear you. So in other words, don't wait till your loved ones are incapacitated to want to go and get somebody's, power of attorney. However, talk to us a little bit about you getting this established and then having this power, and then something may go awry between you and said individual. How does that work? Can you undo it?
Yes. So it can always be undone. You can revoke the power of attorney. So you can just, rip it up and say, I revoke it, and then create a new one naming somebody else in that place. So you definitely don't have to stick with whoever you named, in the first place. But when you are deciding who you want to be your power of attorney, you have to really think hard, because it's a very important decision. You need to appoint someone who you trust, right? Because this person is dealing with your financial institutions, your bank accounts and things like that. And so you definitely don't want to just name anybody to be an agent. You want someone who you trust, that is going to carry out these things in your best interest, and that's not going to take advantage of you.
Okay, so speaking of taking advantage of, right? So this person obviously has the ability to make withdrawals from your account and deposits. Wow, that's a lot of power for a person. So I guess my thought is, what happens with your funds? I have a lot of questions. If the person passes away, right? Do you, as the power of attorney, automatically, you have access, one could argue, do you automatically get this person's money?
No, because once the person passes away, you no longer are a power of attorney. The power of attorney only exists while the person is living. Once that person passes away, your power as the durable power of attorney agent is no longer valid.
I hear you, Keisha. But, sometimes folks are very creative, right? So this is a hypothetical, right? Someone passed away. One could argue that the person is not technically dead until there's a death certificate and banks are notified, correct?
Yeah, but I mean, then whoever is, and we'll get to this position in terms of a personal representative, but whoever becomes the personal representative once that individual passes away, they would have legal right to take action against someone who is fraudulently using the power of attorney once someone passes away, because they no longer have that power anymore. It terminates as soon as the person passes away.
And I always like to assume positive intent, though, because I'm sorry, Shari, go ahead.
Yeah, let me clarify something. So Keisha is going through these different scenarios where you need these different documents at various stages, right? Mm-hmm. So she's covering now disability and the power of attorney. Another document she's going to cover is a living will or advance directive. Those two documents are only functional while the principal, the person who is giving the power, while that person is living. They may lack capacity, but they must be living. Okay. Once they decease, that's when your last will and testament kicks in. And so these three documents have an agent, a person in charge, and that person has a different title per document. So when Keisha mentioned the personal representative is what it's called here in Maryland, she's referring to the person in charge of executing the will once you're deceased. So that person then can look and oversee, look at what the power of attorney was doing during specific periods of time to determine whether or not it was legal.
Interesting.
So it's kind of a check and balance.
For sure. All right, continue. This is good.
Yeah. So the other thing I wanted to mention, and this slide is called a durable financial power of attorney. So that means that this document is in place whether or not you're incapacitated. It goes into effect immediately when you sign it, right? So it doesn't change whether or not you become sick or incapacitated. If for any reason you did not want the person to have power of attorney until you became incapacitated or disabled in some way, then that will be called a springing power of attorney. And so something would have to happen in order for that person to become the agent and to have power over, your involvements and your financial documents and things.
Fair enough.
And normally, if you have a springing power of attorney, that requires a doctor to basically diagnose you and certify that you have some kind of incapacity. And so until that doctor certifies you as incapacitated, then that power would not go into effect for that agent. Most people don't do a springing power of attorney. Most people do the durable power of attorney. And so that power goes into effect immediately. But, as you asked earlier, those powers terminate either when the principal dies, when the principal revokes it, or if the agent dies. And there's also the ability to name a successor agent. So, you really want to name more than one person to have these powers for you, just in case one person passes away or they themselves become incapacitated and aren't able to carry out, these duties for you. You want to have backups. And then also, once you have a divorce filed or, a separation agreement, then the power of attorney also goes away in those instances.
Okay. So just as a recap, a springing power of attorney, hence the word spring. It springs into action if you become incapacitated. So durable power of attorney becomes effective as soon as you sign the document and continue, right? Okay.
Yeah. Yep.
Got it. Thank you.
Okay. The next document, and Shari alluded to this a little while ago, is the advance directive. And again, these documents are valid while the person is still living. So the advance directive is a healthcare power of attorney and a living will combined. And again, this document enables a third party to make healthcare decisions on your behalf if you become incapacitated or disabled. And again, the person who executes this document has to be competent to execute the document. And again, if you have dementia or you're in some kind of coma or something, it's too late. It has to be done while you're able to comprehend and talk and express your wishes. The living will itself is actually instructions on how you want to be treated if you're in a terminally ill condition or in a vegetative state. So for example, you may not be able to speak for yourself, and you may not want any kind of medication. You may want to just, let your death come on naturally. You don't want any kind of assistance. If you're not able to feed yourself, provide nourishment for yourself, you may or may not want to have be fed by a tube or, something like that. So you have the ability to tell your caregiver, whoever you appoint as your healthcare power of attorney, and it also gives notice to your doctors how you want to be treated in these instances. And that part of the document is called a living will. The healthcare power of attorney is, again, the portion of the document that allows you to appoint someone to carry out these things and to make decisions for your health that's in your best interest. In addition to those documents, you also need to have a HIPAA release form because, there is a privacy law with regard to healthcare information. And so in order for individuals to be able to have discussions with the doctors, we do need to have a release form that allows the doctors to talk to you. And if you don't have a healthcare power of attorney or any of these documents in place, if something were to happen to you where you become incapacitated or, disabled in some way, if you don't have these documents in place, then someone would have to go to the courthouse and petition to become your guardian. You may have family members who you don't trust to take care of you that way. Or, you may want someone specific to do those things for you. So in order to make sure that you get the person you want to make these decisions for you, you definitely want to make sure that you have these documents in place. The other thing that I think is very important is when children go away to school, they're 18 years old. We sometimes still refer to them as children, but technically they're adults. They're 18 years of age or older. They may still be in college, but they're technically adults. And so if your adult child is away at college and something happens and they go to the hospital, mom and dad can't rush to the hospital and say, let me know what's going on with my child.
Wow.
They also need a power of attorney to be able to speak to the doctor. So it's very important that if you have someone in your family who is 18 years of age or older, they too need to fill out this power of attorney to allow their parents to be able to talk to the doctors and get information about them.
Wow. I don't even think most people even think about that, to be honest with you. Once you're in college, that's still my baby, right?
Oh, exactly.
Yeah, that's interesting. And so hospitals know that if you don't have that level of authority, unfortunately, and your child doesn't want you to know, they don't have to tell you. Very interesting. And I knew, I used to work on a college campus, and I knew that somewhat as an 18-year-old, they have to get permission for us to give your parent information, and parents would be livid. So I can only imagine.
Right. So if you want to be able to have access to your child's information, you need to ask them to fill out a power of attorney so that you can present it to a hospital or doctor or whoever, so that, they'll be able to give you the information that you may or may not need. But it's up to the child. It's up to the child to decide if they want to sign that for you.
So quick question. What's the difference in a living will and a written one, or are they one and the same?
So the last will and testament, which I'm going to get to later on, is something totally different than a living will. The living will is what I explained. You telling the person how you want to be treated. So, you know, if I'm incapacitated, I can't talk, I'm at a terminal state, or I'm in, you know, a vegetative state, you know, do I want to have nourishment provided to me? You know, do I want to have medication? Do I want you to do anything and everything possible to extend my life with, you know, medication or procedures? Or I just want you to just let me die naturally and don't, you know, try to do any other extra procedures for me?
All right, well, Keisha, I want you to continue, but I do have a quick question, and this is just, I mean, it may be silly, I'm not sure, but if I drew up something and I just typed it up and I got it notarized, legally, does that serve as my rights, my will? Or do I have to like go through a lawyer? Do I have to, you know, do I have to jump through any other hoops other than writing something up and getting it notarized?
So you could write something up. You don't necessarily have to go to an attorney, but there are certain requirements in order for the will to be valid. That you have to make sure that, you know, in terms of like how many witnesses need to sign it, whether it needs to be notarized, you have to make sure all those things are done properly, or else the will can be found to be invalid, and then, you know, it doesn't really work, and it's not going to carry out your wishes.
Hence the reason lawyers are good people, I guess.
That's right, get a lawyer.
Kavon, the one thing that I wanted to, as far as the living will versus the last will and testament, because people often are confused about this topic. A will is an expression of your desires, right? A written expression of your desires. A living will, hence the word living, is an expression of your desires for when you're living, but you're not in a position to articulate them, maybe most likely because you lack capacity. Whereas a last will and testament is an expression of your desires when you are deceased. So a lot of people get those terms confused because will is in there.
You don't even want to know what I thought a living will was.
What'd you say?
You don't want to know. You really don't want to know what my definition of a living will was. My definition was a person that I know. Hey, listen, judge me if you want. A person that is living.
We're here to,
look, you know. I assumed that a living will was just you being on video alive telling what you wanted to happen. That's what I thought a living will was.
Oh, no.
Judge yourself, Shari. I don't care. That's what I thought.
No, because you know why? Because you know me personally. You are my brother, so I expect better of you. Because I live and breathe this stuff. Okay.
I normally wouldn't even admit to it. I'm comfortable now. So there you go. I've always thought that. So I learned something. Carry on, Keisha.
All right. So now we're going to move on to the second D, which is death, right? And so that's when the last will and testament comes in, that Shari indicated. And so, like you said, the last will and testament states how you want your assets to be distributed at death. It also allows you to name a personal representative to handle your estate. So that was that's what I referred to earlier as a personal representative. They are the people that pay your debts off. They distribute your assets. They make sure your last taxes are filed. Those are the things that that's the person that settles your estate. The other thing that you also can do in the last will and testament is if you have any minor children, you get to nominate and name who you want to be the guardian of your minor children. So when you leave things to someone in a will, you may be able to leave things to someone who may not normally, by state law, normally get those assets, right? So that allows you to name other people who may not legally be not entitled to these things. You allow them to be named in your will. And again, in all these documents, the person who's executing them, they have to be of sound mind to execute it, right? And so when you have a will, that allows the judge to see who you named in these positions, and they basically just put an order in appointing them into the various positions that you've asked for them to do. So what if I don't have a will? And a lot of people don't have a will. Y'all like my graphic?
Mm-hmm. No, I'm like, who is this man?
So what do I do if I don't have a will? So you don't have a will. You are determined to have died intestate. So intestate means that you did not have a will. And so the law has an order by which your assets, to who your assets go to when you don't have a will. The intestate laws, they do not address who is going to be the guardian of your minor children, right? So if you don't have a will, then you didn't get a chance to name who your guardian is going to be. And in Maryland, this is an example of how things go, how things are distributed in Maryland. So if you have children, but you don't have a spouse, then your children take 100% of what your asset, what your estate is.
Okay.
If you have a spouse but no children or parents, then your spouse takes 100% of what your estate is. If you have a spouse and minor children, then your spouse takes 50% of the estate, and then your children take the other 50% of the estate.
And this is given the fact that you don't have a plan, correct?
Right. If you do not have a will, this is how your assets are going to be distributed. You don't have a say in it.
In Maryland, because every state is different.
Okay.
Yeah, every state is different, definitely. So this is a Maryland intestate law. So you can see that you don't have control over where the assets go. It's basically what this slide is trying to get to. And there's an order in which every state decides who gets what.
So you're a single mom and you have just one child and you passed away, but you don't have anything written down to say where you want your child. What happens to your child?
So where you said you're a single parent, so you have a children but no spouse, right?
No spouse, and you're divorced, and the only person left is the child. So clearly, from this, from what I'm reading, the child gets 100% of what you have.
Right.
However, where does the child go if the child is a minor?
So we will discuss that, but
okay, I'm jumping the gun. Sorry.
Yeah. So if you didn't have a will, you didn't get a chance to name your guardian, right? Because you didn't have a will, right? Mm-hmm. So we're gonna cover that in 2 more slides.
Got you. Take your time.
And so again, I just did a slide for DC as well. It kind of gives you an outline of what happens if you don't have a will in DC. And you can see it's a little bit different in terms of how they, break it down.
Wow. So even if Shari and I are married but we're separated, I die, Shari still has a legal right to everything that I own.
If you're not divorced and you don't have a will and you're technically legally married, then yeah, the spouse, if you don't have a will saying that the spouse doesn't get anything, your spouse gets whatever the state says that the spouse gets.
Interesting. And I'm sorry to ask so many questions, but what about for those situations where common law you would be considered married because you've been with this person for so long, but you never legally went and got married? And that person, God forbid, you've been with them 30 years, they passed away. And like, do you have a legal right to anything given the fact that you spent your life, half of your life with them?
It depends on if the state recognizes common law. Not every state recognizes common law marriage.
Okay, so you would need to know that.
Yes, you would need to. It depends on what state you're in.
I guarantee you most folks don't know, but that's fine. That's why we Amen.
So this is the answering the question that you just had about if you're a single parent, you die, you didn't name a guardian.
Okay.
So in the will, the guardian is named to basically be the substitute parent in case you pass away. However, if you have a surviving parent, right? So when you passed away, you may have been the custodial parent. You had custody of the child. Mm-hmm. But if you pass away, even if you name a guardian in your will, if you pass away, the surviving parent will get custody of the child. The only way that the surviving parent will not get custody of the child is if that parent is found to be unfit for whatever reason. So, for example, there was a child abuse and neglect case for some reason, or CPS, and for whatever reason, that parent was found to be unfit, right? Or they had their rights terminated. Other than that, they will be the surviving parent to get custody of the child. Now, if you have a situation where you're married, right? You're together. You go on a trip somewhere. You're on I don't want to be morbid or anything, but you go on a trip. You all are on the same plane. The plane crashes and you both pass away. There's no biological parent left to, have custody of the child. So if you don't have someone named as the guardian in your documents, in your will, then someone is going to have to go to the court and petition the court to be the child's guardian. And there could be more than one person who's interested in having that job, but they may not be the person that you want to, have access to your child and to raise your child.
That's heavy.
Yeah. So
I mean, so the kids don't have so my kids are 14 and 12. And so Shari is the godmom, but it's nowhere written that, we want Shari. We haven't had a conversation with Shari, none of that. And we may even have other plans. How does that work? Like Shari can go as a godmom to petition, but she could also be up against father-in-law.
Right. You can have competing petitions of multiple people coming forward to say that they want to take care of the child. And so basically,
Keisha, but what? So I have a 14-year-old. My 14-year-old is capable of saying, "I want to be here," or "This is what my parents told me I should be." Does the judge take any of that into account, or is this just all up to legal? Is this just a legal matter?
Most courts around that time period, around the age of 14, they do take into consideration the child's wishes. But the court, what they look for is what's in the best interest of the child. So they will take into consideration what the child wants, but overall they look at what they decide is in the best interest of the child.
Fair enough. Very interesting.
Yep. So get your will done and put Shari in there as the guardian.
No, but this is the reason why I wanted to bring another voice on, because I feel like I say this and I scream this from the mountaintops and no one listens to me. And so I wanted to bring Keisha on, particularly because of her practice area in family law as well. She's going to speak to some other areas, but we just need to get our houses in order, particularly if we have children. If you don't feel like you own a rock, that's fine. If you're a parent, you need to name someone to have control over your kids and not just leave so much just out there for other people to figure out.
Right. Or for the court to just determine, it may not be what you want. Yeah. But the court's going to make a decision for you, since you didn't give them any kind of guidance based on a will.
Wow.
So when should you update your will if you have one? So you want to update your will if your marital status changes, because most times in your will, spouses name their other spouse as the personal representative, right? So that's the person who's going to carry out your wishes, distribute your assets, file your taxes, make sure whoever you named in your will to get stuff, make sure they get that to them. Most times people name their spouses. So if you get a divorce, you need to update your will to make sure that you appoint someone who you trust. I mean, you may not like your spouse anymore if you get a divorce. You want to make sure you have somebody in that position to do these things. So you might want to update your will if your marital status changes. You also want to update your will if you had some property named in your will, but maybe you gained some other things that you didn't put in your will to be distributed. You want to update your will at that time. If you have additional children, so if you name someone as the guardian of 2 of your children, and then you got your will done, and then you had 2 more children after that, but you didn't put them in you didn't name them as the guardians or name someone to be their guardians in your will, you need to update your will so you can make sure that they're named in the will and the people who you want to raise them is named in the will. If you are giving something away to your grandchildren, you have more, or you didn't have grandchildren when you did your will, you might want to update your will to include them in that. Also, if you had named someone to receive something that you're leaving behind, but before you pass away, that person passes away, you might want to update your will to change that beneficiary so someone else gets that item instead of you name someone who's no longer around to get it. And again, if you have a personal representative who, whether it be through divorce or otherwise, that person is no longer able to serve, or maybe they passed away before you did, you want to update your will to make sure that you name someone who's able to serve on your behalf. Did you have any questions about that?
I always have questions.
That's why I paused.
I know. I'm sorry. But I'm also long winded, and Shari told me about like how long my shows are. So the thing is so I'll ask one question, and I'm curious as to who your demographic is. Like, if you had to explain to the audience who, primarily who do you talk to on a week to week basis? Do they look like me?
You talking about when I talk to people?
Your demographic in terms of your clientele, like who you work with.
I would say, I mean, they look like you, but they also look like other people as well. It's a mixture.
Are they young? Like, are they under 40 most times? Are they established with lots of assets? I mean, like, is there a large pop? I'm just wondering, like, I know a lot of people who really have it together, quote unquote, but never sit down with someone like you to discuss any of this.
Mm-hmm.
And they have great jobs, great cars, and beautiful families. And I'm just wondering, um, when you go to work every day, or do you find that, believe it or not, one of the myths, because you talked about that earlier, is that we don't have it together. But I'm assuming that there is a population of folks that are just like me that really do have it together. That's an assumption I'm making.
I mean, there are a lot of people who have it together. They may be like, putting money into a 401k and like having those things, in place. But at the end of the day, you still need these estate planning documents put into place, because that comes into what I said earlier about, preserving, protecting, and passing on your legacy to create generational wealth. A lot of times we don't, we have things for now while we're living, and then we don't think about the legacies that we could pass on, to create generational wealth.
Sure.
So I think that that's something that, we need to focus more on, is passing on our legacy so that we can create generational wealth, which we don't do a lot of.
Yeah. I mean, it's very interesting. I think growing up as the only child, I know my mom, one of the hot topics in our house was just how I was going to eat. So this was the last thing that would have been on her mind, to sit down with a lawyer, because that costs money. So wondering, for folks who don't have it and would never even be able to fathom being able to sit down and afford a lawyer, I'm wondering what we can do as a community to help those individuals out. And that's more of a rhetorical. It's just something that immediately hits me, because I know growing up, it would have, this is probably was never on a plate.
So let me answer your question a little bit, Kavan, because I know I do a lot of pro bono work, and Keisha does as well. And so in Maryland,
just assume people don't know what that means.
Pro bono work means free, gratuitous legal services. And so the state of Maryland, and I'm not sure about other states, but there are several legal service organizations. These are nonprofit law firms that pretty much serve specific populations. Okay. So there are legal services organizations to provide services geared towards women, geared towards seniors, geared towards low income folks. And I serve on pro bono clinics probably once every other month. This is the extent of my pro bono work, is going through a legal services organization to have what's called a clinic, where you would contact them to say, hey, I want these estate planning documents, but I'm low income or I'm a senior, and you have to qualify through the metrics of that organization, and you'll get a qualified attorney. So the resources are available, particularly in Maryland. I'm not sure about other states, but the fact of the matter is, Kavan, you and I are pretty much similar. My mother was not having any conversations about estate planning, and it was just like, look, how are you going to school, and how are we paying for this, because you got to become somebody, so this wasn't the topic. But I think for our generation, I know enough of us who have great jobs, who own property, we drive nice cars, we have nice things, but we're not planning. And that's who if you're asking for my motivation,
Yeah.
those are the people that I want to speak to
Yeah.
say, hey,
But you can't afford it.
you can afford it.
You can.
You can afford it. And I don't know, I can't speak for Keisha, but I do payment plans. So you can afford it. And with the same vigor and the same energy you use to plan for a trip to
Vacation,
Jamaica, you
right?
plan that a year out. You plan a trip to Jamaica. You planning sweet 16s, 40th birthday parties. Yes, I'm coming for you and your wife. 40th birthday parties and vacations. You need to, with that same energy, plan for when you're no longer here, because the only thing certain in life is that you will pass away. That's going to happen. So
Okay.
plan for it.
Duly noted. Keisha, move on, because she always got to continue, please.
Okay, so in addition to a last will and testament, I know sometimes people hear the word trust, right? And so I just kind of want to go over some differences between a trust and a will. So I already explained that the will, basically expresses your last, your last wishes, how you want things to be distributed, and things of that nature. The will itself has to go through what's called the probate process. So that basically is the will goes, to a judge so that the judge can appoint the personal representative that you actually name in your will. And that process is a public process. So if someone wanted to see what kind of assets that you did have while you were living, and that you left to your, loved ones, they will be able to see anything and everything that has gone through the will, right? So a trust, and additionally for a will, anything that you leave in your will goes directly to whoever you left it to, right? So even if you leave it to a minor, that minor gets whatever you leave directly, from the will. If you have a trust, the trust, you have more control. First of all, it doesn't go through probate, so it keeps all your assets private. And then it also allows you to leave instructions on how you want money or whatever to be distributed to whoever you leave it to.
Nice. So you could say my child is, if my child is a minor, I want them to get X amount over. You can like specify.
Yes. So you can actually put in like a schedule saying, say they, you're leaving them like $10 million. You don't want them to get the $10 million outright.
Right.
So you can actually, you put it in a trust. You can say that they're going to get a certain amount, for at a certain age, and then, another amount when they turn 25, 30. You can actually, decide what schedule, how you want them to, get the money, how you want the money to be distributed. So in that document, you appoint someone who's called a trustee, and that trustee basically carries out and manages the trust on your behalf, so that whoever you leave, whatever you leave in that trust will be distributed how you want it to be distributed. The thing with the trust, though, is that whatever you leave in that trust, whether you put your house in a trust, whether you put a car, whatever you put in there, you have to retitle all those things into the name of the trust. So then the trust will technically own the assets in it. And then the trustee would, just distribute those things the way you instructed them to. So if you have a house, you need to redeed your house so that the trust owns it. If you have a car, anything that you put in the trust, you need to retitle it to be in the name of the trust.
Interesting. I wonder if that has any tax, but whatever. I'll look into it.
Yep. So why might I need a trust? So one of the things that you mentioned was taxes. So one of the reasons why you might need a trust is to protect beneficiary assets from creditors. So again, if you put assets into a trust, then technically the trust owns the assets in it. So that means that, say, you have a brother or a son or whatever that just is bad, has bad credit, like has all these like judgments out there, and you don't want to leave them an inheritance that the creditors are just going to snatch up to satisfy a debt. If you put the assets into a trust, creditors can't get to it because technically that beneficiary doesn't own the assets, the trust owns the assets, and the trust can distribute different things to that beneficiary, from time to time. So that kind of protects their assets from creditors. And the same thing with spouses. I'm kind of going to get to spouses a little more later, but you can protect your inheritance and things like that from an ex-spouse if you happen to have to go through a divorce.
Okay, so but someone has to be stop. Shari already knows. But someone over the trust, right? Like that would be
A trustee is appointed to run the trust.
But you appoint the trustee while you're alive.
Yes.
Right? Okay.
And I have another slide, but basically you can also be the trustee of certain trusts. So you either appoint the trustee and that trustee takes over when you either become incapacitated or pass away, or you can be the trustee while you're living, depending on what kind of trust it is.
So intriguing.
So basically, you still manage everything. Even though it's
trust.
I'm sorry?
I don't think I know anyone with the trust, but I like it. I like it a lot.
So again,
you will.
So again, you want to leave things in a trust for, like I said, someone who's like irresponsible. They're gonna get $10 million up front. They're just gonna blow it. You might want to put it in a trust and like divvy it out, on certain timetables so that they don't just blow everything all at once. You want to do the same thing for minors, so that they don't get $10 million and they're 8 years old.
Sure.
And there's no one to manage the assets. Another reason why you might want to have a trust is that, a lot of times, you may have a family member who has special needs, or who has like long-term care needs, right? And so a lot of times people who have those needs, they qualify for some kind of federal benefit. And when they are trying to qualify for a benefit, the government takes into consideration what assets you have, right? So you don't want to have a family member who has special needs, who's getting some kind of government benefit, but then you shower them with all this money of inheritance, and that makes them ineligible to continue to receive the government benefit. So if you put those assets in a trust for them, those assets aren't counted as assets for them when the government is trying to determine whether or not they qualify for a benefit. And another reason why you might want to have a trust is to minimize taxes, which is what you briefly said. So if the assets are in a trust, clearly they're not counted. Well, in certain trusts, they're not counted, as assets that you actually own, because the trust would own them. So that actually, there's a way to benefit by minimizing your taxes using a trust. You have any questions about that?
Nah, we'll be all day. I mean, I almost feel like in certain situations, it behooves you to put certain things into a trust and possibly even make your spouse the trustee. I just think it's so many directions you can go in that are smart, and that would, man, it's just keep going. That's cool. I like it.
Okay, so I mentioned that I would talk about different types of trusts. So there are many different reasons to have a trust. So what you're trying to avoid or get done, but there are revocable trusts, and all trusts avoid probate. So again, you don't have to go through the probate process, so it keeps all your assets and things private. A revocable trust, you actually continue to own the assets, right?
Okay.
And because it's revocable, meaning like you can change it at any time.
Yep.
You continue to own it, and so you don't get the benefit of having like to minimize taxes or anything, because those assets are still considered to be owned by you. So
yep.
You still, but the benefit of having a revocable trust is in that trust, you probably name someone to manage your assets, right? So you can be the trustee while you're living. So you manage everything while you're living, but you also name a successor trustee. And that successor trustee, if something were to happen to you, that successor would step right in to manage your assets if you become incapacitated or, or eventually when you die. So that kind of goes back to the living will and things like that. That person steps in case you become incapacitated, so you don't have to worry about going through a guardianship case where somebody has to be appointed to make decisions for your benefit when you have a revocable trust. An irrevocable trust is something that goes into place and the trust owns all the assets in there. So that's the way you're able to minimize your taxes, because instead of those assets being attributable to you, they're now attributed to the trust. So, when you file your taxes as your individual self, if you minimize the taxes that you have to pay. And so they, protect your assets. And again, when I said you needed a trust so that you don't, interfere with government benefits, there are trusts called special needs trusts, and they have to be written a certain way so that, if you leave money to someone, it doesn't affect if they're able to benefit from any government benefits.
This is very intriguing. I raise money for a living, so a lot of this reminds me of, well, when we're talking about trust, it reminds me of like donor advised funds, where you literally are putting your money. It's not your money anymore. You're giving it to a financial institution and you're managing it, but you had some say in where you'd like it to go. So but you make recommendations. It's not necessarily. It's very interesting, but it's a lot of similarities as well.
Right. So then the next topic that we were going to talk about is divorce. And the topics that people normally consider in divorce is child custody, visitation, alimony, child support, and marital property. The estate planning part really comes into place in the divorce when we get to talk about marital property. So in child custody, just overall, there are two types of custody, legal and physical. And the legal custody is a parent's right to make long-term decisions for major things like education, religious training, and discipline. And then the physical custody is basically whenever a child is with a parent, they have physical custody of it. So you get to make day-to-day decisions, while the child is with you. You have physical custody. And so just, parents have a constitutional right to have custody of their own children. And so in order for someone not to have custody of their child, they have to be proven to be unfit, right? So either their rights have to be terminated, they have to be unfit in order for a court to grant someone other than the actual biological parent's custody of the child. And I know a lot of people think that, mothers have, presumption to have custody over the child, but that's, legally that's not true. Neither parent is presumed to have a superior parental right. So, both parents are supposed to have just as much right to the child as the other, unless there's a custody order put into place that says, one parent has a different custody over the child.
That sounds good, but we don't have enough time to really unpack that.
And then again, just really quick, child support. People ask about child support all the time, and that really is just a calculation. Everybody, you put in your income, whether or not you're providing for medical insurance. There's certain factors that go into it, but really it's just a calculation that is done to figure out how much, child support someone has to pay. I think the main thing to take away from this one, and I know you have a lot of viewers in Pennsylvania, but I don't practice in Pennsylvania. I practice in Maryland and DC. So in Maryland, the child support ends at the age of 18. But in Maryland, child support ends at the age of 18. But in DC, you actually have to pay child support until the child is 21.
You grown. You ain't no child at 21.
Well, that's not what DC says. DC says keep paying until that adult turns 21.
We have a question, Keisha. Do you mind?
Sure.
If parents have shared custody and one parent dies, can the grandparent of the deceased parent then be granted shared custody with the living parent?
So I mean, in terms of custody in general, like you can come to court and if both parents agree to share, I mean, if the grandparent and the living parent agrees to share custody, they can go to court and basically consent for that to be the arrangement. If there's like a dispute, then it would have to be a trial where the court determines what's in the best interest of the child.
The child, got it.
Yeah. So marital property, and this kind of goes back into why you really need to have an estate plan as well. Marital property is anything that you acquired during your marriage. So I know sometimes people have like separate bank accounts and things like that, but if you're married and you're having income and you've been, putting money into these accounts as a married couple.
Wait a minute.
Come on, because I got in trouble last time when I was talking about this.
Wait a minute.
I got in trouble, so come on.
If your name ain't on the account, it ain't your money.
Yes, it is.
Okay.
Teach them, Keisha, because I got in trouble. Let me tell you, these viewers came for me last time.
If you are married and you have bank accounts, all of those, if it was acquired during your marriage while you were married, anything that you acquired while you are married is marital property. That includes bank accounts,
Amen.
Retirement accounts,
Trust.
Well, everybody, you have to have your separate trust.
Okay.
But bank accounts, retirement accounts,
I'm a share.
The clothes in your house, the furniture in your house,
your clothes,
commingled funds. If you have, bank accounts that are commingled, anything that you acquired during the marriage is marital property. However, I have, down below what is not marital property. So anything that you attain prior to getting married is not considered marital property unless you commingle it, right? So if you had a bank account that you had prior to getting married and you kept it separate and you can show that you had this account before you got married, then that's not considered marital property. If you had that account before you got married and then you transferred the money into the bank account with your spouse, it's commingled. So now it's considered marital property. If you inherit something during your marriage, so that's what I'm saying. If you have a trust and you want to leave your family member something in a trust, that shows that something was inherited during the marriage. And so that would not be considered marital property because it's an inheritance. If you have something that was gifted from a third party during the marriage, that's not considered marital property. If you have a prenuptial agreement or some kind of agreement that excludes certain things as marital property, it's not marital property. And if you have any item or any asset that you can trace to all the stuff that I just listed, those things would not be considered marital property. But if it doesn't,
so this is a personal question. Look, this is my free legal advice. Look, no, I assumed that I was gifted a house, right? That was in my family, and so it's, completely paid off, and it's an asset for, as far as I'm concerned, our family. But it's just me. I'm the only person on the house. Do I need to go put my wife's name on the house? It sounds like what you're saying is that because it was gifted from a third party, she has no legal rights to it. But we're married, and so if I were to die, she would get it. But if we were to get a divorce, she would have no stake.
So I'm going to tell you, if you put her name on the property, then it will become marital property, because anything that's titled tenants by the entirety, that it becomes marital property unless you have some kind of agreement written up, like a prenuptial or something that says that this is not going to be marital property. But when you add her name onto the property as tenants by the entirety, it becomes marital property.
Interesting. So death and divorce, they total things different. Everything happens differently. It just depends on what you have legally written down.
Say that one more time.
I'm assuming that like death is one thing, but divorce is a whole. One can argue divorce is a death, but divorce is very different than death. And death, not everything goes to a person that you're with. When you die, it just depends on what you have written down, I would assume.
So yeah, so death, it depends on, you know, who you leave certain
Shari's
things to.
confused.
And the one thing I know the question was kind of a little confusing, but the one thing that I do want to say is there are certain assets that have beneficiary designations, right?
Right.
So you have like an insurance policy, you know, different things have beneficiary designations. Anything that has a beneficiary designation does not pass through your will. Whoever you name as your beneficiary on your insurance policy, that is who is going to get that asset. So, for example, if you are married and you name your wife, your current wife at that time, as the beneficiary on an insurance policy, you get divorced and you do not change that person from being your beneficiary on your insurance policy,
She's still the beneficiary.
your ex-wife will get the money, and you get remarried, your ex-wife will get the money that you left her as a beneficiary on your insurance policy. That's why you need
all the
to
time.
make sure, that's why you need to make sure that you update all of your policies to have an updated beneficiary, because if you forget and then you pass away and you meant to put your new wife on there, too bad, so sad.
A lot of folks mad out here.
Your new wife is going to be really upset because now your ex-wife gets all the money.
Wow. Okay. Very interesting.
Yes. Make sure you update those beneficiary designations.
And Kavan, I think the point of all of this is to get people to see how complicated but simple at the same time things can be. Everything is going to be different for everybody, depending on what their situation is. So it's hard. That's why I was like, what are you asking? Because it's hard to answer a question in a vacuum without, like, you asked your question and I had 3 more questions to ask you. So if we were in a consultation, you wouldn't get an answer from me. You would get 3 more questions. I could have understanding.
And in my head, it all made sense. It was more of it wasn't even really, it was rhetorical in a sense where I'm starting to put all the puzzle pieces together.
For you,
why it wouldn't.
Yeah, you're putting them together for you in your mind based on your situation.
Right.
But we have to be careful on a platform like this because we don't want someone to put things together incorrectly, because here's what really happens on these things. People say, oh, these 2 great lawyers who are beautiful did a wonderful presentation. I know a little bit about a little bit. So now I'm going to write my own will and I'm going to write my own trust, because everybody is DIY these days. Do it yourself. And my experience, I don't know about Keisha's, in estate administration, that's the back end. That's the probating your will part, is that I get a lot of these DIYs who have screwed up royally. And so that's why I spend a lot of time trying to educate on the front end to say, hey, let's avoid this. I can clean it up on the back end. It's going to cost you a little pretty penny. But guess what? You're not going to be here to clean it up. Whoever's left is figuring it out. Get it right on the front end.
That's good.
And not only that, people share copies of what they did. And again, like Shari said, your situation may be totally different. So you're copying and pasting what somebody else got done, and it's not going to work for you. So everybody should have a consultation with an attorney so that they'll know and they're getting advice directly, specifically for their situation, and not, what somebody else got advice for a totally different situation.
No, I'm completely sold on that. Appreciate that.
So I'm just gonna, just because this is kind of part of a divorce, I'm not gonna spend too much time on it, but alimony. People ask about alimony all the time, and typically you're not gonna get alimony unless there's like a 2 to 3 times difference in the salary, from one spouse to the next. But in general, there are 2 types of alimony. There's rehabilitative alimony and indefinite alimony. Rehabilitative alimony, which is the most common, basically says, like, for example, if you have a housewife who, didn't really work or finish school or whatever, and they were taking care of the kids, and then you get a divorce, rehabilitative alimony is put into place so that that person has some kind of income to supplement them while they're finishing school or, furthering their education, to put them in a better position to support themselves. So that's rehabilitative alimony. Indefinite alimony takes into consideration your age, any type of illness or disability, and the fact that you may not be able to make a reasonable progress to support yourself, or if the standard of living between the parties was just like just really, varied. Like if they got divorced, one party would have like an extravagant, lifestyle to support themselves, and the other one was just like living off of like bread and water.
Yeah.
And so in general, alimony ends when at the death of either party, if the person who's receiving alimony gets remarried, or one person goes back to court and convinces the court that alimony needs to end, so the court terminates it. Some of the things that courts look at, and this is particularly in Maryland, they look at when they're trying to determine alimony. They're looking at the length of the marriage. The longer the marriage, obviously, the better. If you've been married for like 2 months and you want alimony, the court's gonna be like, goodbye, like, whatever. So they also look at the age and the physical and mental health of the individuals involved, the reasons for the divorce. So, if you were cheating, and then you want to get a divorce and say, I want alimony, that's something that they factor in when they're deciding, whether or not you should have alimony.
Really?
Yes, they look at the reason for the divorce. And these are things that they just consider, right? So I'm not saying one thing weighs more than the other, but these are certain things that the court looks at. They look at your ability to self-support, be self-supporting, the time necessary for you to, get the proper education and training to get suitable employment, the both parties' standard of living during the marriage, the contributions of each party. So even though, you were a stay-at-home mom, you're still making a contribution, right? So even if you're not getting money, so the court does consider that contribution as well. They consider the monetary and the non-monetary contribution. They look at the ability of the payor to meet his or her needs while paying alimony. They look at any agreements between the parties. They look at the financial needs and the financial resources of each party. And then, for example, if whether the award would cause a paying spouse who is a resident. So say like you're, in some kind of institution or something where you have to pay something. Would you be eligible for medical assistance earlier than you would otherwise, based on the fact that you have to pay alimony? So those are some of the factors that they look at when they're trying
men, of course, can apply for alimony as well.
Yes.
So, and let me just put a pin in here. And I don't do family law because I'll be the attorney fighting because I don't have the capacity. But I will say I'm at the stage in marriage where we've seen people get married and now we're seeing people get divorced, right? And in large part, and this may be my small little circle, but the men are out here winning these days. The men are out here winning, and meaning when we talk about alimony and child support and caregiver, we're typically speaking about the female being the recipient of alimony and the female being recipient of child support because the female is the custodial parent of the child. But I am seeing normally,
yeah,
right. But I am seeing a trend and a change where, the tide is turning. Depending on that, because women are working in executive positions a lot. We have some dads that are staying at home now, and so I want people to be really clear that this is not a gender thing, because guys call all the time. No. It's not a gender thing. It is really based on who is, who is capable of doing it, who is capable, and who has been doing what in the household. It's not based on gender roles.
Definitely. Yep. So the law is there. So, they apply it. And if it applies to the man or the woman, that's who's going to get the child support or the alimony or whatever. So it's definitely not gender specific. Guardianship. So I know we talked about guardianship of a minor, but there are times when you have an adult who needs a guardian because they, have been disabled in some kind of way. You can have the guardian of a person, and that guardian would take care of the disabled adult's personal and physical needs. So they would take care of them on a day-to-day. You can also have a guardian of that person's property, and that person would manage the disabled person's financial affairs and makes financial decisions. So it's kind of like a power of attorney, but in a power of attorney, that adult is naming someone that they want to, take on this responsibility in terms of being their healthcare power of attorney or their or their durable power of attorney to take care of their financial needs. A guardian most times is somebody is petitioning the court. So the person is legally disabled because they lack the ability to make or communicate responsible decisions, either because of mental disability, disease, habitual drunkenness, or some kind of addiction to drugs. So then you have a family member who may, see all these things happening and go to the court and petition and basically make a case to say, like, this person can't take care of themselves, they can't take care of their financial needs. And if the court finds that, this person is indeed unable to do these things on their behalf, then they'll appoint somebody to be the guardian for them. One of the reasons why I wanted to bring this up is, again, sometimes you have spouses who, one of the spouses becomes legally disabled for one of those reasons, and the other spouse is appointed to be their guardian. So in the case of divorce, you may need to appoint somebody other than your ex-spouse to be your guardian, because there may be a conflict of interest. If you're getting divorced, you can be divorced for some really, bad reasons. You don't trust the person, or they're abusive, or whatever the reason may be. And so if you have someone who is the guardian of a spouse who is somehow disabled, you may need to have that person step down from being the guardian and appoint somebody who is going to have your best interest at heart. So things that you need to do when you get a divorce. Again, you need to revoke all of your financial power of attorney. So you make sure you appoint somebody who you want to, manage your assets if something happens to you, if you become incapacitated. You want to revoke and sign new healthcare powers of attorney, so that, again, you have someone managing your healthcare that you trust. Because I don't know if sometimes people get divorced and it's amicable and all that stuff, but if you are married and getting a divorce and you don't trust that person anymore, you might want to appoint somebody else as your healthcare power of attorney. Again, as I mentioned before, if you have someone listed as your beneficiary in your life insurance, annuity, whatever, anything that has a beneficiary designation, you want to make sure that you change those designations, because someone who you might not want to have that money will get it if you do not change the designation. And you also want to draft a new last will and testament, so you can appoint, a new personal representative to carry out your last wishes. You might want to, appoint another trustee or a guardian. And, if you had a close-knit family and that family also had maybe appointed your spouse or ex-spouse to, hold some of these positions, you might want to make sure your family members remove that spouse as well as beneficiary or other fiduciary duties. So that is the end of my presentation. My contact information is on the screen. I am located in the Washington, D.C. area. I can be reached at 1717 K Street Northwest, Suite 900 in Washington, D.C. And my phone number is 202-627-6809. And also, you can follow me on social media and also visit my website. So I hope that the information that I provided was helpful and informative to those who were watching and who tuned in. And again, if you are located in Washington, D.C. or Maryland, and you have, want to set up a consultation, you have some questions about your individual situations, feel free to contact me on any of these social media or email, website, and I'd be happy to set up a consultation with you.
Awesome. I really appreciate you. This was super informative, and I'm going to take a step back and do something a little different. I'm going to remove myself, and I would like Shari. We got about 15 minutes. We can't exceed 15 minutes. We didn't want this to be over an hour and a half, but I'd like you to ask Keisha, as the host, a question or two that you think absolutely needs to be discussed.
Oh my gosh. Keisha, you were so thorough. He should have warned me. I would have had some questions prepared. A question that needs to be discussed. So, part of the reason why I wanted you to present, because you've had this amazing family law practice and you do estate law. So, I guess the real question is, what are you seeing in practice that makes the connection for you? Because I think some of the viewers might not understand the complete connection between what you do and see in family law practice and the importance of estate planning. And so I understand it and I understand your presentation, but if you can just give a brief explanation of how you see the two going hand in hand and why it's necessary for the viewers to know that.
Well, in general, with estate planning, as we already discussed, I think that everyone should have an estate plan for the reasons that I pointed out in the presentation. You know, if you're become disabled in some kind of way, you need to make sure you have the documents in place so that the right people can be put into place to, you know, to service you in those positions. The reason why I combine the divorce and estate planning is because a lot of people may do the estate planning part and don't look forward to the possibility of getting a divorce, and things that you may have put into place for estate planning may need to be changed. And I want to, you know, give people an idea of what they need to consider that they, you know, have to revisit or change if they get to the point where they need to, you know, file for a divorce. You know, like I said, I think, you know, major thing is, you know, if you have beneficiaries on your accounts, right? You think like, oh, I got divorced, you know, everything is fine. But if you don't remember to change the beneficiaries, then that affects your estate, right? You going through a divorce affects your estate planning because you didn't plan, or you may not, you know, maybe you don't care if your ex-spouse gets it, but I'm sure you probably want to name someone else to get those assets. And so, you know, you have to be mindful of, you know, making sure that your estate plan is up to date when you get a divorce, right? When you're going into a divorce, so that your estate can pass on, you know, your legacy to who you want it to be passed on to and not to somebody else.
Okay. I guess it's one more question and a comment. I know that most recently, I don't know if the onset of it is COVID or not, but on the state administration side, you know, probating wills and dealing with individuals who have died intestate without a will, I am seeing a number of parents who may have had sole legal custody or shared custody leave with no plan, really, not even a will. They're dying intestate, and the family, they're reaching out to me saying, hey, we know that the other parent either didn't want to be involved or the other parent is, you know, not unfit declared by the court, but isn't a good parent, quote unquote. And we want to figure this out. How do you deal? I know for me, it's gut wrenching. This is why I want to do a lot of the discussions up front to say plan. But how do you deal with handling receiving a case like that, where you have a child essentially with the legal parent with a dispute by maybe some other family members?
I mean, really, the onus is on the family member to prove that the biological parent who is left, the living biological parent, is unfit, because like I said before, every biological parent has a constitutional right to have custody of their child. And so the only way for a biological parent, even if you don't think that that person should have, or, you know, custody of the child, the only way that you're going to prevent them from having custody is if you go to court and you have to prove there's some, you know, exceptional circumstances, or that the child is unfit. I mean, the parent is unfit for someone else to have custody of that child. Now, if the biological parent wants to, you know, just agree to the arrangement, that can definitely take place. But if there's like an actual dispute, you know, you would have to prove that that biological parent is not fit, and there's a you know, some kind of circumstance that, you know, requires the court to give somebody else custody.
Yeah. And the last thing I think is more so of a statement. I know when we talk about divorce and estate planning, we're typically talking about or discussing keeping assets away from the other spouse. I've actually recently found in three different scenarios that were brought to my attention where there were divorced couples, so two individuals were divorced, but one of the spouses left the ex-spouse as trustee of their trust. The ex-spouse didn't know about it, and it's just like, I don't even know that I like you. Why did you leave me this responsibility? And clearly didn't tell them. And in another case, left the ex-spouse personal representative. And still, their time had elapsed. Neither situation was a situation where it was a spouse that didn't change or didn't update their documents. It was intentionally done by the person who had the will drafted after the divorce, that they left the ex-spouse in charge. And so I think that's even how we got to having this particular topic, because I had called Kavan just like, man, talking about relationships, just how, because that's what Kavan and I talk about offline, just human relationships, and how you were married to someone, for whatever reason you got divorced, but you still trust them enough to hold this particular role, even though you couldn't remain married to them and haven't been married to them for decades, because in both of these cases, these were elderly individuals. So there was a lot of time that had lapsed. But so I wanted to just kind of put that out there, just the importance of maintaining relationships with other individuals. Because one thing that I see, and it's gut wrenching when people contact me, they know they should have an estate plan, and we get down to the nitty gritty of each plan, and they literally cannot identify a healthcare agent, a power of attorney, or a personal representative, because they're like, I simply don't trust that person to that extent. Yikes. So that last one wasn't a question, just my statement.
All right, so we're going to close out. We're at 1:21, so roughly 8 minutes or so. The one question I do have, based off of this comment this brother just made: divorce, just don't do it, not worth it. Then he says, speak to it, move on. Now listen, he's speaking, one can assume from experience. But that being said, one of the questions I had for you, and this could be really, really, really quick, in your personal experience, and I'd like both of you to answer this: do you feel like anything really could be worked out in the greater scheme of things? And of course, we know certain things just cannot. But when you look at all the cases and the folks that you've come in contact with, do you honestly think that some of these folks couldn't work it out? Personal opinion.
I mean, that's really hard to say, because it's like case specific. It's really case specific. I mean, I'm sure there some things that some people who are getting divorced could probably have worked it out. And it really depends on what you can handle, and what the two people in that relationship value and are willing to work on and sacrifice. You can't work on something by yourself.
Yeah, you're a lawyer. I forgot who I was asking. So here's the thing. No. That I guess that makes a lot of sense. So which leads me to another question. Do you think you're what's the word? Desensitized to like the feeling aspect of divorce, given the position you're in? Do you allow yourself to emote during this process, or are you strictly what does the law say and what does the law stipulate?
So I would say in general, in every, no matter where you are, some people have, or a lot of people have implicit bias. So that means that like how you react to things is determined by your own experiences sometimes, right? And sometimes you haven't experienced something, so you can, have a more subjective view on it. But like everybody's a human being, right? So you're going to bring your life experiences to, to the situations that you're listening to. So for example, if you may have experienced some of the things that your client is talking about, or your potential client is talking about in a consultation, you may be able to sympathize more with it because you've had a firsthand experience with it. Sure. But in general, because it's not our particular case, we definitely have, can be more diplomatic about things and think about it from a purely, legal standard instead of an emotional standard. So while you may be able to understand and sympathize, at the end of the day, when you're going to court and you're presenting something to the judge, right, it can't be on you have to craft it a certain way so that you can, show the different sides and, why certain things are emotional. But when you're presenting, you can't present it, in an emotional state. So, like I said, I think that you can, probably sympathize and empathize with someone's story based on your own personal experiences.
Okay.
But, it's a case by case basis.
Quick question. Are you and Shari friends?
Yes.
I can tell. So the last question of the evening is...
Well, did I answer the question the way she did or something?
Yeah, listen, y'all are a lot alike, and I talk a lot with Shari. I'll just leave it there. A lot alike. It's a good thing. It's a great thing. I think. So the last question I have is, what question do you have for me? And I really appreciate the time you spent with us today. Any questions that you have for me?
Just I guess for me, I wanted to know. I know you have a wide array of topics that that you talk about on your show, and just basically like what just wanted to know like what are you trying to do with your audience? Like who are you trying to reach? What's your goal?
Good question. Pretty much is open. So my primary, I guess, target audience are men. Men from all walks of life. What we try to do for the Brothers Brunch is provide men with all the tools that they need to be successful so that they can show up as better husbands, fathers, and friends. But what I find, regardless of who my target audience is, those who are tuning in and those who are actively participating and those who are actively leaning into these conversations and discussions are women. The women who love the men that I ultimately want to touch. And so it's the same with the physical Brothers Brunch. It's the same with the, me going out and speaking to men. I typically get a lot of DMs saying, hey, I want my son. Hey, I want my husband to be involved. So I try to go into every situation and every conversation with the end in mind. I know who I want to hear a lot of these gems. We talked about health. We talked about wellness. We talked about, prostate, and all the things that men are supposed to be doing. And a lot of the responses I got were, I had to get on top of him or sent him the link. And so, I'll take it however I can get it, because at the end of the day, I want my audience to ultimately walk away as better husbands, fathers, and friends. And if we give them the tools that they need to be successful, whatever way they get it, mission accomplished.
Excellent. Well, I mean, it's definitely something needed in the community. And I think, that that's a great objective to have. And, I hope everybody's taking advantage of it, of the resources that you're providing.
I think so. I think so. It's met with some skepticism, of course. Believe it or not, we do get brothers that might watch the re-show that will make comments or say thank you, we appreciate it. It was it depends on the topic, because I can't say finances and estate planning is the sexiest topic, right? But it's a topic that's needed in our community. And long story short, I know brothers are getting it one way or the other. It just takes a little time. So it's about consistency. I think one of the things we lack in our community is being consistent, so if this is going to be a platform where we offer this, then let it be the platform where we offer it, and we do it unapologetically, whether you have one person tuned in or you have 30, it really doesn't matter. I appreciate you today. We got a comment says, appreciate you, brother. Keep sharing the knowledge. See, that's affirmation. Shari, any closing thoughts? I'm going to let you close this out.
Oh, me? Closing thoughts. I want us, the listeners and the viewers of the Brothers Brunch, to really take estate planning seriously and to take it to heart and to get a calendar out and set a date for when you will plan your estate. You can, depending on where you are, do some research, go to legitimate sites, state governmental sites. Some governmental sites have healthcare directives, the living will, they have power of attorneys. Don't go to random sites. Go to legitimate sites, which are government sites that are backed. If you cannot afford an attorney, go to those sites, get something developed. Again, you need something crafted specifically for you. So save up the coins, go see an attorney, but develop your plan. I cannot stress it enough. And Keisha sees the same thing. It's not hard. It's not complicated. Or it doesn't have to be. Let me say, it doesn't have to be hard or complicated. I want everyone today. This is your charge. COVID is the alarm that's sounding for us all. All of us have been devastated. All of us, at least I know myself, have lost individuals that I know were here today, gone tomorrow. Some had plans, some didn't. We treat life as if we have infinite control over it, and we don't. And so we purchase properties, we have children, and we build this amazing lifestyle while we're living, but we don't take that same care when we're no longer going to be here. So that is what I want to leave everyone with, is to set a date today that you're going to do something. You're going to do some research. You're going to schedule a consultation, or you're at least going to begin saving. But most people don't even contact law offices to even know how much it costs before they say it's expensive. So contact
I know how much it costs.
Get the cost, save for it, make it work, and just do it.
Yeah, it's levels to it, retainers and all that good stuff. It's so many ways. And you mentioned before that, some folks do take payment plans. But yeah, anything is worth it. It's going to cost you something. So thank you both today. We are maybe a minute or so over our allotted time of an hour and a half. I really appreciate it. This is a conversation well needed. I'm going to ask for your thoughtful consideration by hanging on in the green room for a little, and we are going to get out of here. All right. Thank you.
All right. Bye, guys.
This was Food for Thought. I'm Kavan Terman, your host, and thank you for joining us.
Uh-huh.